We're not much different in height, so she should be fine right about there.
I put it on speaker view and pinned this, so I shouldn't pop up when you put it on full screen.
Yeah, this doesn't go full screen though. This is what's being shown there. The Zoom doesn't show up there.
But if you do full screen and then screen share, this will disappear.
Yeah.
But it would be nice on the Zoom if we could see the person's face who's presenting.
Yeah, you're going to see them.
Show up.
Yeah, it's going to be a small square of the person speaking. Yeah.
Gotcha.
All right, and we're sharing the entire.
We're co-hosting. I don't know how to change the display.
Yeah.
Just to learn what you're doing.
It's not.
It was showing a while ago.
Yeah, I'm waiting for it to kind of catch up. I think it's lagging a little bit for some reason.
Took a while ago. Green is for camera. What's the red for?
Power.
And is it going to take sound in through here?
So they're going to see that, but it's okay. That's the where do you want it?
We put it at the bottom last time.
Bottom right? There? Is that good?
Yep, looks good.
Okay.
It's recording. Do we know that we've got sound going into the Zoom?
Yeah. Well, are you on the Zoom? Hello, test. Hello, test 1, 2, test. Is she hearing me? Okay, I didn't hear it. Okay, you're good. You're ready.
I'm shorter. Spotlight right on me. So it looks like we still have a few people coming in. So I'll wait for them to get seated and then we will begin. Oh, no. Oh, dear. All right. Well, I thank you all for coming to our final session today. We will be talking about what happens to my stuff after death, or maybe more technically titled estate planning and the Crowsdale Village policies when somebody dies. As you know, we are have an objective here to just kind of give you as much information as possible about your choices and your preparation for the end of life. And today we're just going to be looking at what to do to make sure that your loved ones and your possessions are taken care of after you pass. I cannot believe that we are down to week 5. What a ride it has been. We only have one more session after today. It's a supplemental session in Bowles. I'm sorry. Did we? Yeah, it's going to be in Bowles. Let me say that some of our sign-up sheets have said that the legacy letters is in the paint and pottery. That's when we thought not a lot of you would be interested, but we had a better turnout on our wait list or on our sign-up sheet. So we actually will be doing that session in Bowles. Is that right? In Roy's room. So look at that. My slides are wrong. It is actually in Roy's room. We've got a good 20 people that have signed up. And Miss Jane Hoover will be assisting with that session. I just want to remind everybody that we have a collection in the library of supporting documents and books and things like that for this Death by Design series. So you can always check things out there. And of course, we have our website that we are putting all of our presentations on. All of the slideshows are on the website, and other supporting documents, links to other resources and websites. So you can get to that website by going to Vibrant, and you will see our little logo tree. You can click on that and it takes you to the Death by Design website. And up in that upper right-hand corner, you'll see resources and presentations, and you can click on those to get to what you're looking for. So today we have an attorney with us, Miss Dory Dixon. Dory is an attorney and founder of the South Point Estate Planning in Durham, North Carolina. She has been practicing for 18 years and in a focus of estate planning, elder law, and special needs planning. In addition to her time in the office, she enjoys teaching and was an adjunct associate professor of law at the University of North Carolina School of Law, teaching elder law, estate planning, and special needs planning. Dory is a former president of the North Carolina chapter of the National Academy of Elder Law Attorneys and former chair of the Elder and Special Needs Law section of the North Carolina Bar Association. Whew. She lives in Durham with her husband, Josh, and son, Gray, and their dog, Walker. And in her spare time, she enjoys gardening and hiking. Her longest hike was the Make-A-Wish Trailblazing Challenge, which was a 25-mile hike from Hanging Rock to Pilot Mountain to raise money for the Make-A-Wish Foundation. I'm tired just thinking about that. So without further ado, I'm going to hand it over to Dory, and she's going to talk to us about estate planning.
Okay, can everyone hear me? Okay, just want to make sure that mic is working. I'm Dory. Thank you very much for having me here today. And I'm going to talk to you about estate planning and some things that you want to make sure you have in place. A lot of times people say to me, well, I don't need an estate plan because I don't have an estate. So what do they mean when they say that? Well, a lot of times when people think about estates and they think about estate planning, they think about tax planning. There is an estate tax. If your estate is over a certain size, that's where the federal government taxes your estate at your death. Right now, though, for 2022, only estates over $12.06 million are subject to estate tax. There's no North Carolina estate tax. Now, this exemption amount is actually going to go down in the future because the law that's in place right now is temporary and it expires in 2025. And when it expires, it's going to go back to the old law, which was $5 million indexed for inflation. And so by that time, it'll probably be around a $6 million exemption. So it'll be estates above $6 million that would be subject to estate tax. So that's a lot of times what people are thinking about when they say, well, I don't have an estate. I don't need to do estate planning. But estate planning is about a lot more than just taxes. And so this is pretty much all we're going to talk about taxes today. We're going to talk about all the other important reasons to have a plan in place. So there's different goals when we talk about estate planning. And we're going to go through each of these goals. One is planning to avoid probate. Probate is the process where your executor, if you have a will, or if you don't have a will, someone else gets appointed by the court to administer your estate. And it's all overseen by the clerk of court. So that can be a long process, and we'll talk about what that looks like. So we try to find ways to avoid probate if possible. Another goal for estate planning is planning for incapacity or planning for long-term care. So I know that I guess one of the titles is what happens to your stuff after your death, but I'm actually going to talk to you a little bit too about what happens during your life, because for me, that's the most important thing. Making sure that you're taken care of while you're living. Other goals with estate planning might be planning for minor children. If you're leaving anything to a grandchild, making sure that it passes to them in a way that they can receive it without it being tied up in the courts. And also, sometimes estate planning involves planning for beneficiaries with special needs. If you have a loved one that you plan to leave property to who is receiving any kind of government benefits, such as Medicaid or SSI, then there are special considerations when you're planning your estate. So when we talk about estate planning, there are basic documents that we all need. And these are kind of the main ones here. One is your last will and testament, which a lot of people are familiar with. Another one is your revocable living trust. Not everyone needs a revocable living trust, and we'll talk about the difference between a will and a trust to see, where you might benefit from that, but not everyone needs one. What I do recommend everyone have is a financial durable power of attorney and a healthcare power of attorney. Again, to me, I think what's most important is making sure that you're taken care of while you're living. Even though I do talk about what happens to your property after your death, these bottom two documents, the durable power of attorney and healthcare power of attorney, are the most important to make sure that you're taken care of. So what happens if you do nothing? If you don't have any kind of plan in place? Well, you do have a plan. It's just not necessarily the plan that you want. The state of North Carolina has a plan for you. They're going to decide who gets your assets at your death. It can increase the cost of administration of your estate, both at your death and also if you're living and a guardianship has to be put in place for you. So we want to avoid the state's plan. We want to make sure that the plan that's in place is the one that we choose. So what is the state's plan? So in North Carolina, if you die without a will, the state says who gets your property. And a lot of people assume that if you're married, everything just automatically goes to your spouse, but that's not the case. It depends on how things are titled. If you have assets that are joint with your spouse, those will pass by right of survivorship to your spouse as joint owner. But if you have property that's in your individual name, it's not necessarily going to pass to your spouse. If you have no children and you're survived by your spouse and a parent, then your spouse is going to receive half of your real estate, the first $100,000 of your personal property, bank accounts, things like that. And then the remainder of the property will be split between your spouse and your parent. If you do have children, then it's going to be split between the spouse and the children. And in that case, the spouse actually gets a little less. So the spouse gets half of the real estate, the first $60,000 of personal property, and then the remainder would be split between the spouse and the child. If there's just one child, it's split 50-50. If there's more than one child, then the spouse only gets a third, and the children get the other 2/3. So it's really important to make sure that you have something in place. And I see this a lot of times with second marriages, where there is property that is, maybe the residence is in one spouse's name and they'd never put it in both spouses' names. And then suddenly the spouse that owns the property dies without a will. And now the spouse and the children that are not that spouse's children own the property together. And so there's a dispute about whether or not the spouse can continue living there. So it's important to have something in place to make sure things like that don't happen. So one goal, the goal, what we just talked about was making sure that the plan you want is the plan that is in place for you. But we also want to try to plan to avoid probate. Probate is the process where your executor takes your will down to the courthouse. If you don't have a will, another family member probably would get appointed by the court to administer your estate. And there are costs associated with probate. It's $4 for every $1,000 that passes through your estate. And in North Carolina, there is a cap on that. The cap is $6,000. So you won't pay more than the $6,000 for at least that portion of it. That's just a fee off the top. That's a fee that gets paid to the court. But that's not all the fees associated with probate. There's other fees that have to be paid, as well as in many cases, people will need to hire an attorney to help with the estate administration. The clerk's office cannot advise you on how to fill out the forms and how to do the accountings. So it ends up being somewhat costly, as well as taking a really long time, often to get the assets to your loved ones. So if we can avoid that, we try to do it. So that's where the revocable living trust can come into play. So I like to refer to the living trust as sort of a will substitute. It does the same thing as a will. It says who gets your property at your death, but it does a little bit more. One, it also provides for someone to manage your property for you if you become incapacitated, and it avoids probate. So to the extent that you have your bank accounts and things like that titled in the name of your living trust, then those assets will not go through probate at your death. Again, I don't think everyone necessarily needs a living trust. It's dependent on what kind of assets you have and who they're passing to. But some things to consider if you're thinking about whether or not you would like to have a living trust. One, If you don't want people to know what your spouse or children are inheriting from you, then you may want to do a living trust, because the probate process is all public record. And so at your death, when your estate is being administered through the courts, there is an accounting that's done that shows everything you owned as of date of death, all the expenses that are paid after your death, and then what passes to your beneficiaries. So if you want more privacy in that, then you might consider a living trust. If you want to avoid long delays before property passes to your loved ones, a living trust can be helpful there as well. With the probate process, you would be looking at a minimum of 4 months before you get to the point where things can really be distributed out. And that's because it will probably take a little time before you get it appointed as the executor. And then there is a 3-month creditors period where you really shouldn't distribute any funds out during that time, because we're waiting to see if there's any creditors claims. So that's one reason to consider a living trust, particularly things like if you have a residence that has a mortgage. One thing people don't realize is that you can't use the estate assets to pay mortgage payments. So that means that your beneficiaries are going to have to come up with a way to pay that while they're waiting for the estate to be administered. Living trust sometimes helps avoid that issue. If you want to avoid the expense of probate, then you might consider a living trust. If you've got assets that would be passing through and would cost a large probate fee, then you may consider doing a living trust to avoid that. If you own a business, oftentimes you don't want that business interest to be tied up in that probate process. So that's another consideration for doing a living trust. And if you own property in another state. So if you have real estate in another state besides North Carolina, what happens is you would have to do, or your executor would administer your estate here in North Carolina. And then they would also do an ancillary probate in the state where your other piece of property is. So then you've got 2 probates. So I just want to do a quick rundown of the differences between the will and the living trust. A will is very easy to set up. You just state who you want to get your property. If you're working with an attorney, they'll prepare the will for you. You sign it, and then you're done. You typically don't think any more about it unless something changes and you need to update it. With the living trust, it's a little bit different. It's still pretty easy to set up. You're still going to state who gets your property at your death and then sign the document when it's ready. But there is an additional step to take after the document is signed, and that is titling assets in your living trust. So the reason we want the living trust is to avoid probate. And the reason it avoids probate is because your assets are actually in the name of the trust at your death and not your name. So I have a living trust, and so my checking account is not in my name, Dory Dixon. It's in the name of my living trust, Dory Dixon Living Trust. I still fully own the account and could do anything I want to with it. Nothing changes from that standpoint. It's just the name on the account is different. And because of that, at my death, that account will not go through the probate process. But it did require me to contact all my banks and go through, a bunch of paperwork to get the name changed. So that is a little bit of a tedious task there, but ends up with a lot less administration later on. Okay, a will is going to be administered publicly under the supervision of the court. A living trust is administered privately by the trustee that you have chosen. With a will, any property that's passing through probate, again, is going to pay those probate fees, $4 for every $1,000 passing through probate. Plus, there may be some additional court fees as well as attorney's fees if an attorney is assisting with the estate. Whereas the trust has typically nominal costs to administer because you're not having to pay that probate fee. You're not having to do accountings with the court. If you've got a family member as trustee, maybe they're not charging you a fee to do that. If you have a corporate trustee, like a trust company or bank, there would be some fees there, but a lot of times people just use the spouse or children as trustee, and they don't charge a fee for that. With the will, your assets will be frozen at death until someone is appointed to administer your estate. With the trustee typically has more immediate access to those funds. They just need the death certificate and the trust document showing that they're the successor trustee, and then they can step in right away and get access to those funds. So to give you an example of what a probate estate might look like, I've got a couple here, Jack and Jill. They're married, and Jack passed away first. And this is the property that they owned at their death. So they have a house that's in both of their names. So that house is going to just pass directly to Jill. She doesn't have to go through a probate process to have the house retitled to her. It's just going to pass automatically to her because it's in both of their names. But Jack also has $400,000 in an investment account. He has a business interest worth about $250,000. He has some real estate in Florida that's just in his name. He inherited it from his parents. And then he has a $350,000 IRA where he's named Jill as beneficiary. So the IRA is going to go directly to Jill. She just has to fill some paperwork out with the company holding the IRA. She does not have to go through probate for that. But the things that are going to go through probate is that investment account, the business interest, and the piece of property in Florida. So for the North Carolina probate, the probate fee is going to be based off the investments and the business interest. And so that's going to be $2,600, just the fee to the court at the beginning, not including attorney's fees, not including other fees associated with probate. And then Jill's also going to have to do an ancillary probate in Florida to pass title to the property in Florida. And that can be fairly expensive as well. I had one many years ago where it was, I think, a $5,000 fee for that Florida real estate to be probated. And again, that's not including attorney's fees. Those are just fees to the court. So it can be expensive, and it can take a long time to administer. So again, that's why we want to try to think about different ways that we can avoid probate if possible. So I said I was going to talk about some things too, that not just what happens at death, but also planning for incapacity during your lifetime. That's another goal of estate planning, making sure that we have things in place so that you're taken care of if something should happen to you, if you are no longer able to manage your own property. Why do we need to worry about planning for long-term care? Well, the Department of Health and Human Services estimates that 70% of all people over age 65 will need some form of long-term care at some point in their lives. And who pays for long-term care? I know a lot of you are probably familiar with all of this since you're in a CCRC, but most long-term care is paid out of pocket, out of your personal savings. If you have long-term care insurance, that may pay a portion up to all of the long-term care, depending on what kind of policy you have. A lot of people think Medicare pays for long-term care, but Medicare only pays for skilled nursing care for a brief period of time, up to 100 days, and not always a full 100 days. So it's pretty much going to be paid for out of pocket. And at some point, if you spend through most of your funds, then Medicaid is going to help pay for long-term care. And Medicaid is actually the largest payer of long-term care expenses. So what we want to avoid by having a plan in place for incapacity and a plan in place for long-term care, we want to avoid, one, running out of money. We also want to avoid if we have a home and we have a spouse or child living in that home, we want to avoid leaving the house unprotected. We want to avoid risking the health of family or spousal caregivers. Family caregivers, particularly spouses, are at very high risk for serious health problems. And there's a typo in the slide, it says programs, but it should say health problems. So we want to have things in place so that we're not putting our family caregivers at risk of health problems themselves. So I've got another couple here as an example, and I guess I've liked the name Jack and Jill because different couple, but their name's Jack and Jill also. They've been married for 40 years, and Jack has advanced dementia. He's in a nursing home, and they're paying the nursing home cost, which is about $10,000 a month. And Jill is starting to worry because they are going through their savings pretty quickly. And she's worried that they're going to run out of funds and then that she won't have any money to help pay for her needs. So she's thinking that she might like to look into applying for Medicaid to help cover the cost of Jack's nursing home care. Luckily, Jack has a power of attorney in place so that Jill has the ability to manage his property for him, and also to submit an application for Medicaid if needed. Power of attorney, again, is a document where you choose someone to manage your property for you if you become incapacitated. And it's very important to have that in place, because if you don't have something like that in place and then you are no longer able to manage your property, then most likely the court will have to get involved in that. Not all powers of attorney are created equal, though. And it's very important to think about what kind of powers you want to include in that power of attorney. This is a document I highly recommend that you get from an attorney. If long-term care is a concern, I would recommend that you meet with an elder law attorney to discuss what kind of powers should go into the power of attorney, because some powers of attorney are very limited when it comes. In fact, a lot of powers of attorney are very limited when it comes to planning for long-term care. One power that you might want to include in your power of attorney is the power to gift assets. For example, the power to gift assets to your spouse. And you might be thinking, well, why would I want my agent to be able to gift my assets? I don't want them to give away my things. I want them to use them for me. Well, and that's typically how a power of attorney works. Your agent is supposed to use your assets for your care, for things that you need. But when it comes to planning for long-term care and potentially applying for Medicaid, the ability to gift assets to a spouse can be very helpful. So, for example, when you apply for Medicaid, your house is not a countable resource. You don't have to sell it. You can apply for Medicaid and receive Medicaid to pay for your nursing home care, and still own your house. However, if the house is still in your name at your death, then Medicaid has something called estate recovery. And that is where they seek to get paid back at your death from your assets, which typically are your home. So we want to try to protect the home for the spouse who is still at home. And we want to make sure that there's not going to be a claim against that house. So in Jack and Jill's case, Jill meets with an elder law attorney, and she finds out that Jack can qualify for Medicaid once his assets are below $2,000. She could keep half of their countable resources, which is mostly everything except for a few things like the house I mentioned before. She can keep half of the countable resources up to a maximum amount of $137,400. Anything above that amount will have to be spent down in some way. The house is not countable, so they can keep the house. That's not going to be a problem. But because Jack's name is on the deed, if he receives Medicaid at his death, there will be a claim against the house. So the elder law attorney says, well, let's put the house into your name. That way we don't have to worry about the state having a claim against the house at Jack's death. So they look at Jack's power of attorney, and Jack's power of attorney does allow gifting to the spouse, but it's very limited. And this limitation is actually really common in powers of attorney. This says that Jill can make gifts to herself of Jack's property in amounts not to exceed the annual exclusion amount for federal gift tax purposes. Does anyone know how much that is? Yes, $16,000, that's right. So she's not going to be able to transfer the house into her name because the house is worth more than $16,000. So she's limited in what she can do there. One thing she can do, especially, very fortunately, there was a new power of attorney law that came out in 2018. And now she does have the option of going to the court and asking the court for permission to make a larger gift than what's allowed in the power of attorney. But that does require going through a court process. It's going to take longer. It's going to be more expensive than if she just had that power in the power of attorney to begin with. So we've got another couple, Jim and Susan. And Jim and Susan are, they find themselves in the same situation as our prior couple. But Jim has a power of attorney that allows gifts to Susan, and there's no limitation on the amount for gifts to his spouse. So she's able to apply for Medicaid for Jim, and she can transfer the house into her name so that the state won't have a claim against it at his death. But there's one more step that she takes at that point. She wants to make sure that Jim is taken care of if something happens to her. What if she predeceases him? Well, right now they have a will. We call it a sweetheart will. I leave everything to my sweetheart. So she leaves everything to Jim under her will. So if she dies first, then the money that she was able to protect for her care and the house that she was able to protect is just going to pass back to Jim. And so he'll lose his Medicaid until he spends through all of those assets. And the house will have a claim against it at his death. So what she decides to do is she sets up a special needs trust for Jim under her will. A special needs trust is a specific type of trust, and the law, both federal and North Carolina law, allows spouses to set up these trusts under their wills for one another. And basically what happens is, though, at her death, instead of everything going directly to Jim, it's going to go into a special needs trust for Jim. Their kids can be the trustee and can use the money in the trust to supplement Jim's care. Because Medicaid only pays for some things. It doesn't pay for everything. They can hire a geriatric care manager. They could hire some companion care, get new clothes for Jim, anything that he needs. They can use the trust to pay for that. And Medicaid allows that trust and allows him to continue to get Medicaid to cover the cost of his care. Then at his death, if there's any money left over, then that is anything that's left in the trust at his death will pass to their children or to whoever Susan decided she wanted to leave it to, and is not subject to estate recovery. So she's been able to protect quite a bit of their property versus our earlier couple who had to go through the courts to do so. One thing I always like to mention when I give these presentations is the importance of caregiver agreements. And it doesn't necessarily have anything to do with estate planning, but everyone should know about this. If you hire someone to provide care for you, you have to have a written contract in place for that care. And that contract has to meet certain requirements, which are all listed here in the PowerPoint, so you have them. And if you don't have these requirements in place and you pay for that care, Medicaid can treat those as gifts and penalize you by not paying for your care. And this happened to one of my clients. I was actually contacted by someone in the administration at a CCRC, and they contacted me and they said, you know, we have a long-term resident who started out here in independent living, and then she, you know, went into assisted living and then nursing home care, and now she has used up all of her funds, and we need to apply for Medicaid. And her daughter just applied for Medicaid for her, and they got a denial. And the denial was because they had hired caregivers. And they'd actually hired someone that was, the CCRC had a list of recommended caregivers that other residents had used. They had done background checks and all kinds of things. And so when the daughter needed to hire a caregiver for her mom, she asked the CCRC who they recommended, and they gave her a list, and she hired someone off that list. And, but they didn't have a contract. And so when she applied for Medicaid, Medicaid said, well, you didn't have a contract in place, so we are going to treat all of those payments as gifts. And what Medicaid does, if you apply for Medicaid, they look at the last 5 years to see if you've given anything away. Now, you can give things away to your spouse. That's why earlier when we were talking about transferring the house to the spouse, that's allowed. But you can't give it away to other people. And so Medicaid has a rule a lot of people are not aware of. And that rule is if you pay a caregiver to provide care for you and you do not have a written contract and you do not have a doctor's letter stating that the care is needed to keep you out of a nursing home, that it is going to be presumed that you made a gift. And under the Medicaid rules, currently, for every $7,110 that you give away, that's 1 month Medicaid will not pay for your care. Well, they had paid for caregivers for years. Starting in independent living, they still had caregivers when they went to assisted living. They didn't pay for any in the nursing home because most of the care was provided there. But Medicaid calculated a 3-year penalty. So they said, you're out of money. You otherwise qualify for Medicaid, but because you didn't have this contract in place, we are going to penalize you. We're going to treat it like a gift, and we will not cover you for the next 3 years. So the CCRC called me to see if there was anything that we could do to help. And in this particular situation, we were able to get the penalty reversed. We had some really good facts on our side. One, we had the fact that the CCRC had vetted these people. It wasn't just someone that they found, through their neighborhood or something like that. But the biggest key in this case was that the daughter was disabled. And under Medicaid rules, her mother could have given her everything years ago with no penalty. And she would have qualified for Medicaid years earlier. But the daughter didn't know that. And so they had just paid for her care for years until she ran out. And so she actually saved Medicaid money. And so they did reverse that penalty. But we were, again, lucky we had those facts. That's a very unusual circumstance. So I always want to mention these caregiver agreements. And like I said, you've got the slides so you can see all the requirements there, to make sure that you have something in place if you are paying a caregiver. If you're using an agency, there typically will be a contract, but a lot of times people are using someone that they found through their neighbors or friends or their church. And so it's just important that you do have that stuff in place. So we've talked about what happens if you have a power of attorney that is limited, that doesn't give you necessarily the powers that you need to do long-term planning. But what if you don't have a power of attorney in place at all? Well, if you don't have a power of attorney in place at all, then the court is going to have to appoint someone to be your guardian. So I've got another couple here. This is Bob and Ruth. And Ruth has advanced dementia, and she's no longer able to manage her accounts. She has never signed a power of attorney. Bob and Ruth go meet with an attorney to see if she can sign one now, but the attorney says, I'm sorry, she does not understand enough about what we're trying to do for her to sign this document. So we're going to have to go to court. Guardianship proceedings are something we really want to try to avoid. Like, we want to avoid probate, but we really want to avoid a guardianship proceeding if we can. It's very similar to probate. Everything's public record. There's accountings that have to be done. There's a lot of costs associated with it. But there's also, there's the difficulty of just even starting out with a guardianship. You've got to have your loved one declared incompetent by the court. And the first step is filing a petition with the court that says, my spouse or my parent is no longer competent and needs to be declared incompetent. And that petition is served on that person by the sheriff. And there's no other way to do it. I wish that you could avoid the sheriff having to serve that paperwork, but they have to serve it, and they have to give it directly to that person. And, if you have someone who has dementia and they see the sheriff coming to them and giving them paperwork, it can be very confusing and very upsetting because they don't understand why the sheriff is there. Maybe they think they're in trouble. So it can be very hard for the family. But that is unfortunately the first required step there. And then what happens after that paperwork is served, a guardian ad litem is appointed for, in this case, we've got our couple, Bob and Ruth. So Ruth is going to have a guardian ad litem appointed for her. And that guardian ad litem is an attorney that is appointed by the court, who is really serves as kind of the eyes and the ears of the court, and who is trying to determine what's in Ruth's best interest. So they're going to go meet with Ruth and make a determination of whether or not they think that Ruth does need a guardian. And they're going to talk to Ruth's family members and decide who should be that guardian. And then there's going to be a hearing before the clerk of court. And Ruth doesn't necessarily have to be there because the guardian ad litem will be there on her behalf. But at that hearing, the court will decide whether or not Ruth is incompetent and then appoint someone to be her guardian. In this case, they did appoint Bob as her guardian. So let's look at what assets Ruth has. She had $300,000 in an account that was only in her name. They own a house jointly. It's in both of their names. And Bob gets appointed as general guardian for Ruth, so he can make healthcare decisions for her and he can manage her assets. Well, there's a lot of fees associated. So based off the $300,000 in the account in Ruth's name, they're going to pay a guardianship fee to the court of $1,200. Also, Bob has to be bonded by an insurance company. That's to make sure that he doesn't misuse her funds. So they have an annual premium he has to pay. And in this case, every year he's got to pay them $3,000. He also can't sell their house without court approval. So even though he also owns the house, It's owned by both of them. So if he needs to sell it, he's going to have to go through the courts to get permission to sell the house. And then if the court grants that permission and he can sell the house, then Ruth's half of that money will go into the guardianship estate. And they'll have to pay another guardianship fee. And they'll have to increase the bond premium. So there's going to be additional costs. And then Bob is going to have to file annual accountings with the court, showing every penny that he spends out of that guardianship estate for Ruth. If he wants to, let's say they want to hire a caregiver to come in, or she needs to go into a nursing home or assisted living facility, and he needs to pay that monthly fee, he has to go to court first and get permission from the court to pay that fee. So it can be very expensive and very tedious. So again, we want to try to avoid, ever having to go through a guardianship. And if Ruth had had a power of attorney in place, then they wouldn't have to go through that guardianship, because Bob could just step into her shoes as power of attorney and they would avoid all those costs. So we've got, I've got a little bit of information in here about planning for a loved one with special needs, but I know also we're probably coming to the end of our time and might want some time for questions, or we're good. Oh, I didn't know that. Okay. Okay, great. Well, so do want to touch a little bit on another goal of estate planning, and this may be different for different people, but planning for someone with special needs. This is becoming more and more important and more relevant to more people, because 1 in 6 children in the US have a developmental disability. And those children may or may not need government supports. They may not be able to work. So when we talk about special needs planning, what we're doing is we are trying to plan to preserve financial security for that individual with special needs, to make sure that they are taken care of, to make sure that we preserve any benefits that they might be receiving from the government. And oftentimes it involves a special needs trust. So we talked about special needs trust for spouses a little earlier. You can also set one up for a child or anyone. So another example here, we've got a child, Nathan, he's an adult with autism. He's not able to work. He currently lives with his parent. He gets some income from work programs, not enough to really fully support himself. He gets a little bit of SSI. SSI is supplemental security income paid from the Social Security Administration. And he gets a little bit of Social Security disability insurance that he receives based off his dad's work history. And his dad has passed away, so he now gets a little bit from there. He really doesn't have any other assets, and he currently receives Medicaid. Medicaid pays for caregivers for him. He pays for all his medical expenses. So Nathan's mom is trying to think, okay, what should I do for Nathan when I pass away to make sure that he's taken care of? I don't want him to lose his SSI or his Medicaid because he can't support himself. And I don't know how long the other assets will last to take care of him. So what does she do? Well, a lot of times people don't do anything because they don't know what to do. So they just don't make a decision. Well, that would be bad in a lot of ways. One, if she doesn't have anything in place, then, we've got all the stuff we talked about earlier with intestate succession and the court deciding how your property passes and the probate fees, et cetera, et cetera. But also, Nathan may not be competent to receive property directly, which means not only is there going to be a big cost at the beginning to administer her estate, but then when it goes to Nathan, it's going to have to go through a guardianship estate as well. And so there's going to be, it's like a double hit. So it's going to be that $4 on the 1,000 for the estate administration, and then another $4 on the 1,000 for the guardianship, plus the bond premiums and things like that. And that property is going to cause him to lose his SSI and his Medicaid. So there's going to be a huge expense. He's going to be losing his benefits. It's not a good idea. So we do want Nathan's mom to do something, to put something in place. Well, a lot of times my clients will say, well, I'm just not going to leave anything to Nathan. I'm just going to leave it to his siblings. They'll take care of him. That way we don't have to worry about him losing his benefits. Well, I don't recommend that either. There's a lot of problems with that. One is, you know, we all have good intentions, but sometimes things change, and maybe that sibling's not going to be able to take care of Nathan. What if that sibling goes through a divorce or gets into an accident? What if they die before Nathan? And that money that was meant to be there for him is now going to that person's creditors or going to that person's beneficiaries under their estate. So the money's not really protected. So I don't recommend doing that either. So one thing that she can do is she can set up a special needs trust for Nathan. And that trust can receive all of the property at her death that she wants to leave to Nathan. Maybe she still is going to leave some to other siblings. But anything that passes to Nathan would go into that special needs trust. She can name the other siblings to be the trustee. There's also a lot of wonderful nonprofit organizations that will serve as trustee. And that money will be there to help supplement whatever Nathan might need, but he'll still be able to keep his benefits. So it's a win-win there. And we've avoided a lot of extra cost, and we've avoided a loss of those valuable benefits. So that is everything that I have specifically here, but I can always talk more. Any questions that you guys have?
Let me finish with just 4 slides.
Oh.
And we're gonna open it up for maybe bombarded with these questions.
Okay.
Thank you.
That was very, yes, absolutely. I just wanted to review real quickly, actually, the Crowsdale Village policies with regards to when somebody passes, what happens to the possessions, what happens to the apartment, to the cottage. First, talking a little bit just about the timeline. In most of the contracts, and of course you want to go back to your contract, but in most of the contracts, we talk about a 30-day limit on particularly your executor, your family, being able to come in and empty out the cottage. The earlier contracts actually state that the payment for your cottage, your apartment, actually stops at the time of death. But then Crowsdale Village realized that that wasn't very smart financially. So they changed the contract a little later into our life, our Crowsdale life. And the later contracts will say that you do pay for the cottage or the apartment. Your estate would pay for that up until you hand in the keys. Your executor hands in the keys. If for some reason it goes beyond 30 days, Crowsdale, of course, will continue to bill until those keys are handed in. And if it is in excess, there is a clause in the contract that says that if your apartment is just not getting cleared out, nobody's making any movement on it, the Crowsdale has the right to take the possessions out, maybe put them in a storage unit so they can flip that unit and continue to get income from it. So Things that need to be turned in at the time of death, as I talked about, the keys, we need all of the keys. So that would be the door 7 key, however many you've been issued, your apartment or your cottage key, your mailbox key, garage door opener, pet, and any dining room card or fob. And if you still have your resident directory, we would appreciate that. All of that stuff gets turned into the marketing department. Many of you will not be here when all of this is happening, but the navigation department, the marketing department are working very closely with your family members to make sure that they understand this process. And I think it's good for you to know, just so you can prepare and you can prepare them. With regards to people who maybe have moved in within, say, 5 to 7 years, and you might still get some entrance fee returned, depending on what type of contract you get. There is some specific language in your contract. I often just say, to go read that contract, but a letter of request for that fund from the executor or the administrator needs to go to our business office, along with an official death certificate and a state of North Carolina letters of testimony. Crowsdale Village will not issue any refunds of remaining entrance fees until the vacated home is remarketed. So none of those fees go back to the your estate or your executor until the apartment or the cottage has actually been sold and we have received all of that money for that sale. So it can be at the earliest, maybe 90 days after you've turned in the keys. It'll probably be longer than that because we can take up to a couple months to refurb an apartment. So it could be 6 months before you actually see a refund, if in fact you are getting one.
Okay.
Yes.
Could I ask a question?
Mhm.
Are they able to name a trust as instead of it going to the estate?
Probably. Good question. And so the question is, sorry, are you guys able to name a trust instead of maybe a will?
Instead of it going to the estate.
Instead of it going to the estate. I suppose if there is a trust involved, we would be working with that. And if you don't have a trust, then we're going to the estate. Okay. Other things just to be mindful of, and as again, we're working with the executors or the family members, the storage units often get overlooked. I was talking with a family member today about their loved one's storage unit. So if your loved ones don't know that you have a storage unit, particularly here in Homestead, and where it is, what you might have in it, just make them familiar with that so that it might be a little bit of a light bulb. Sometimes family members come in and they're like, I had no idea there was a storage unit. That needs to be cleared out. We are working with them to make sure that they're forwarding mail, stopping the newspaper. If there is medical equipment, we do accept medical equipment here at Crowsdale if we need what you might have. So either going through myself or sometimes I connect in with the therapy department to make sure that we get those donations and get them to the right places. All items must be removed from the residency. Sometimes people say, okay, I got everything I wanted. So the rest of it's yours. I don't want it. We do ask that you remove everything from the residency. It does not need to be cleaned at the time of you turning in the keys. We will do that, but all the furniture and whatnot needs to be removed. Spectrum equipment, there's actually a procedure for returning the Spectrum equipment, either at Spectrum or sometimes at the UPS store. And that we have a nice 2-page front and back flyer that we often give to family members that has all this explained on it. And we also have donation, groups as well. If you don't know our wonderful resident, Jerry Smith, he works very closely with his church to get amazing amounts of furniture and stuff for people, immigrants who they're sleeping on the floor. They, don't have anything. So a lot of the possessions that somebody doesn't want, they actually go to good use. I want to somewhat end with a little bit of a note. How many of you in here went to our Death Cafe on Wednesday? Great. I loved that. I thought that was a really cool environment. I felt like we had some great conversation with everybody just kind of talking about what they thought about death and dying and just the whole process involved. One of the resources that Death Doula had talked about was this book called The 4 Things That Matter Most. And I was intrigued by that, and I really started to think about that. This book basically focuses on doing 4 things before dying. Saying thank you to the ones that are important to you. Say I love you to the people who are important to you. Say I forgive you. And say forgive me. I thought those were 4 very powerful things to kind of remember. We're talking about when you're gone, but this right here is things to do and think about while you're still here. So, as I mentioned before, we have a one more session, which is the legacy letters next Wednesday. And those 4 points I just talked about can be good thinking points for that particular session. I learned from Judith today that we are also looking to get a bus together to go to the Green Burial Site, Blue Stem, which was here at our expo, in early November, I believe November 9th. So that's in the planning stages, but you can kind of keep an ear out for that. Maybe look for a sign-up sheet where we're hoping we're having to coordinate a lot of people and figure out who can drive the bus and things like that. But that's another thing that we've kind of got on the docket as well. So you all got an evaluation tool. This one's a little different. I did not ask you about the temperature in the room. But it's actually just looking at the entire program. So we've gone through 5 weeks, and I'm interested in knowing more about what you liked most about this program, what you wish we covered that maybe we didn't hit, and what other programs might you like to see? This was obviously end of life, death and dying, planning. Is there anything else that you might say, hey, I would love a couple of sessions on, I don't know, dementia or on something else. So feel free to think about that. You can return that evaluation tool in the back on the table when you leave. Or, of course, you can return it at the life enrichment counter in that little box. That is all I have. And now I want to open it up for questions. And, okay, so we have some microphones. Do we have anybody to hold the microphones? It's not relevant. We're all going to be pretty much. Yeah. I have got a microphone, and I'm going to give one to Judith. I'm going to get back here. I saw this angle up first. Yes.
Right. Okay, I have a revocable trust. And my investments and things are stated as being divided between, it's a very funny wording, between my two sons.
Uh-huh.
That's all I need.
And can you repeat the question?
Okay, so the question is, if I have a living trust and my investments, now, are you saying that the trust states your investments are to be divided a certain way?
Well, I've also let the, it's TIAA, has it stated.
Okay, so the question is, I have a living trust and I have provided that everything is divided between my children. I imagine it says per stirpes is the,
Via something, something, something.
Oh, okay.
Given a specific wording.
It may be actually referencing the trust. So she's saying she was given specific wording with how to divide those investments among her children. So what I think is probably happening, and she wants to know, is there anything else she needs to do? So one thing to keep in mind, so having the living trust is a good first step, but not the end step. So if you have investments and those investments are, say, an individual brokerage account, not a 401k or IRA, but just a regular investment account, you want to make sure that that account is, the title on the account is the name of your trust. What I think you may have with it sounds like you filled out some beneficiary paperwork with TIAA, and that's probably for retirement accounts, like a 401k or an IRA, something like that. Is that a 403b maybe with TI? Okay, some sort of retirement account. So retirement accounts cannot be titled in your living trust because they have to be owned by you as the individual. So you will name a beneficiary on that account. I typically do not recommend that you name your living trust as the beneficiary of a retirement account. And the reason why is because when you name your estate or your trust as a beneficiary of a retirement account, and when I say retirement account, I'm talking about 401ks, IRAs, things that are tax deferred. When you name your estate or your trust as beneficiary, then that estate or trust has to take distributions from the retirement account within 5 years after your death. Whereas if you name an individual, there are different rules. So if you name your spouse, they'll be able to potentially roll it over into an inherited IRA and be able to take distributions over a longer period of time. For an adult child, if you name the adult child as beneficiary of that retirement account, they will have 10 years to take distributions. So when I say take distributions, because it's a deferred, since the taxes have been deferred on that account, the 401k or IRA, just like when you reach a certain age, you are required to take those minimum distributions. When someone inherits that account from you, they will be required right away to start taking required minimum distributions. And for an adult child, that is now a 10-year period of time that they can stretch it. If you name your living trust directly, then that would be a 5-year period of time that it would have to be paid out. So it's just going to mean that the taxes are going to be deferred for less time, and there's going to be a more rapid payout and more taxes paid. If you have a trust set up for your children, so maybe you've got your let's say at your death, everything goes to your children, but it's going to be held in trust for them either for their lifetime or until a certain age. Then what you would do is you would name that specific trust as beneficiary of your retirement account. And that will allow it to get that same stretch as if you'd named the person themselves.
And quick follow-up. For a checking account, I just need to say it's in the trust.
For the checking account, you want the name on the account to be your trust name.
Okay. And how about a car title?
I'm sorry, what was that?
Car title.
Car title. I don't typically recommend titling your car into your trust unless you have maybe some very valuable vehicles. And the reason why is because there are usually simplified ways to transfer the car at death. And when you put your car title in the name of the trust, a lot of times your auto insurance carrier will charge you at a business rate instead of the individual rate. And so the premiums will be more expensive. And since there are easier ways to distribute the car at death, I usually don't recommend it. For example, if a spouse dies, the surviving spouse can transfer the first $60,000 of personal property without having to do an estate administration. So that's a real easy way to transfer most cars. So I usually don't recommend it because I think in the long run, you could end up paying more money by paying those higher insurance premiums.
More questions? If a couple has in their will that everything directly goes to the spouse, is there anything that has to be prorated?
Yes.
What?
Anything that passes under, so basically, the will just says who gets the property. So that means you get to decide that it all went to your spouse instead of whoever the state decides gets it. But any property that's in your individual name, that's not joint with your spouse, or doesn't name your spouse as the beneficiary, will go through probate. So if you have an individual checking account or an individual savings account, CDs, brokerage, that sort of thing, that will go through probate. Your vehicle, if it's in your individual name, will go through probate. There are, like I said before, some easier ways to transfer that vehicle. But I recommend, as a follow-up to the question about the vehicle, is you can make your vehicle joint with right of survivorship. So I would recommend that for spouses, that it be joint with right of survivorship, so it just automatically passes to the spouse. But anything that is in your sole name that doesn't have a beneficiary named goes through probate.
Okay, so it's covered if you have beneficiary.
Yeah, so if you have you can have like an investment account can be transfer on death to a beneficiary, and that would avoid probate. I will say that sometimes I don't like always, you can name beneficiaries on investment accounts and even on some checking and savings. So for an investment account, it's called TOD, transfer on death. And for a checking or savings account, it's usually called POD, payable on death. And you can name beneficiaries that way. And that works really well if you're leaving everything to an adult beneficiary who doesn't have any special needs, who doesn't have any creditor issues or anything like that, and they can receive that property directly. The downside, and I think that's great for someone who's leaving everything to a spouse or to, if they only have one child, it works really well. If you have more than one child, I don't like that as much. And the reason why is because there's not one place where there's money to pay bills. And so what happens is all of your money gets divided up by the banks and goes directly to those children as beneficiaries. And then one child is going to be stuck paying all the bills and then trying to get paid back from someone else. Or if there's a house and they're trying to pay mortgage or taxes or things like that, there's always going to be one child who is stuck paying for all of that without help from other people, including your funeral expenses, things like that. So I think beneficiary designations work great for naming spouse, or if you only have one child, because they're going to pay for anything anyways. But when you have multiple children, it can sometimes just get a little murky.
Information about requesting a refund of your filing fee. Says you have to provide a state of North Carolina letter of testamentary. What is it?
So the letter of testamentary is what you would get if you had a will and your executor was appointed by the court. So you may or may not actually need that letter of testamentary. If they do have the option of naming a trust to receive that payment, the refund, then you wouldn't have letters testamentary, and you would just show that the trust was named as the beneficiary of that refund, and you would get it. Also, if you don't have a trust and you don't have a will, you won't have letters testamentary either. Letters testamentary are when there is a will and you get appointed by the court. So your will, is called a last will and testament. So letters testamentary are where you appoint the executor of the will, where the court appoints the executor of the will. If there's no will, then it's letters of administration.
In that same area, you were saying that if you do money back from Crosdale, sometimes you won't get it for 6, 9 months. When does the clock stop ticking for the amount of money that you get back? At the time of death or 6 months later?
Well, for example, if after so many months, you would get X number of dollars back.
Yeah, I think the clock stopped ticking at the time of death. So then they calculate at that date how much your refund would be.
So they don't have to wait until you rent it again.
No, but what they do is make sure that everything is cleared out. So if it takes 30 days, 45 days, then it's actually that date, not your date of death.
So it's the date the keys are.
Yeah.
Establishing a revocable trust, it says the costs are including attorney fees. What are the attorney fees?
So you said that it says the costs are including attorneys. Are you talking about the slide?
Or just on the slide?
So
Everything says plus attorney fees.
yes, so that's for probate, not for the living trust. So if your estate is going through the court process to be administered through probate, then if you hire an attorney to help with that process, if your executor hires an attorney, the attorney is going to charge fees for that. And the fees, most attorneys charge hourly for that. And so it would be, for example, if I'm doing an estate administration, my hourly rate is $390. My assistant's rate is $175. My assistant does most of the paperwork for the estate administration, but that's where it gets costly because you have to do accountings to the court. And so a lot of times it can be difficult for people to know what needs to be included in the accounting and do it themselves. So they hire an attorney to help with those accountings. And that's what you're paying for, is preparing that paperwork. That's for a probate estate. And so the fees will vary based off how much work is involved for the law firm. Most law firms do charge hourly in North Carolina. In other states where probate is really expensive, the attorney, like California and Florida, I think they tend to get just a percentage of your estate regardless of how much work they do. So, but again, that's just for probate. With a living trust, you're typically not paying the attorney very much at all, because most of my clients who come in to administer their parents' estate who had a living trust, they might come in for an initial meeting where we walk through kind of what steps they need to take. And then they're able to handle a lot of it themselves because there's not paperwork that has to go to the court. So it's more of they check in as needed with questions, but it's a less active role typically than with the probate.
I have a quick question about the return of entrance fee from does that earn interest during that period? Until it's given?
I'm not sure. Josh Brown, tell you, my guess would be no.
It is my understanding, and you said this, that you want to avoid probate because probate is expensive. I also heard, well, you don't want to set up a trust because setting up a trust is very expensive. So is it pay now or later, or what can you give me a contrast of the difference in the cost for probate and setting up a trust?
Yes, the probate is almost always going to be more expensive than the cost of setting up the trust. In that example where we showed the Jack and Jill and Jack passed and they're paying $2,600 in probate fees. That's not including any attorney's fees or anything. That would be significantly more than the cost difference between setting up a will and a living trust. So you're almost always going to spend more to set up a living trust because it's an additional document and there's additional work involved there. But the fee is almost always the difference between the will and the trust is almost always going to be less than it would be to pay for the probate. But did you have you look like you had another question? No, okay.
I got an impression that you were saying at one point that a living trust is a good way of being able to make sure you're cared for yourself when you become incapable. Was that accurate?
So the living trust does have provisions in it so that if you become incapacitated, your trustee can step in to manage property for you. You still need a financial power of attorney. And the reason why, I have a living trust and my regular accounts are all titled in the name of my living trust, but my retirement account is not titled in the name of my living trust because you can't do that. And my house is not titled in my living trust. It's in my husband and my name. So if something happened to me, he's my successor trustee. He can step in to manage the bank accounts that are in the trust as my trustee, but he'd also need to be my power of attorney if he needed to talk to the company that holds my retirement plan, or if he needed to sell the house for us. So both of those documents are important to have.
If you had documents that they were drawn up quite a while ago, is it reasonable to have a lawyer of some sort, you or some other sort, examine what you've got and make recommendations on what should be changed?
Yeah,
How do you go about that?
If it has been a while since you've had those drawn up, it's probably a good idea to have them revisited. And one of the reasons is, I mentioned this earlier, we got a new power of attorney law in 2018. We also got a new law regarding retirement plans in 2020. And so some of the language in documents prior to that time might need to be revised. So for example, if you have with the retirement account, the change that was made in 2020, if you have any retirement accounts that are payable to trust, like for a minor child or something like that, the language would be different now, that it would need to be updated for that change in the law. With the power of attorney, if you have a power of attorney that was done before the change in 2018, it's still valid. It didn't automatically become invalid. It's just going to be referencing the old law. And some things did change with that new law. Some things needed to be specifically stated under the new law that it wasn't required under that old law. So it's not a bad idea to just have it looked at to see if there's any changes. Also, if you did it a very long time ago, things in your life may have changed. So for example, things like powers to do long-term care planning in a power of attorney may not have been important when you were younger and wasn't included in your plan. So just if it's been a long time, it's not a bad idea to have it looked at. But again, your power of attorney, if it was done before 2018, is still valid. It didn't become invalid.
And how important is it to make sure it's in this state versus your paperwork in a different state?
That's a good question. So we do have a law that states that, for example, your will. Wills in different states have different requirements for what makes them valid, or what makes them what we call self-proving, meaning that you don't have to have affidavits from different people at your death stating that you signed the will, because the will itself proves that. So different states have different rules with that. Some states might require 3 witnesses. North Carolina requires 2 witnesses. And we also require a notary. Some states don't require a notary. So there could be differences. If you have a will that was executed in another state, it may not meet North Carolina requirements. However, that doesn't mean that it's invalid. North Carolina does honor wills from other states. It just means there's going to be some additional things that your executor is going to have to do at your death to prove that will is valid. So right now, in the past few years, they came out with a process where basically what happens is we would need to reach out to the attorney in the other state and get them to fill out a form stating that it was valid in that state at the time it was signed. So it's just extra steps that have to be taken at death, but it's still valid.
Keeping attorneys in
Yeah.
employed.
Yeah.
This is something you might not know the direction for, but I'm just thinking, okay, you've given us information about all these papers and everything we should have. What is the guidance that a person needs when their spouse, that where do we take all these papers and what do we do with all this stuff when we don't deal with this stuff?
That's
too complex.
No, that's a good question. One thing I will say is I do not recommend putting these important papers in a safe deposit box because at your death, your safe deposit box is sealed. So if you have your will in the safe deposit box, they won't be able to access the will in order to get appointed as your executor. And so it's sort of that's an issue. So what I do is I have a fireproof safe at home, and that's where I keep my important documents. You can get ones that have a key, or you can also have some that have a punch code. So you could give that code to the person who's going to be your executor or trustee so they can access it. That's for your will. For things like healthcare powers of attorney and financial powers of attorney, your healthcare power of attorney, I recommend if you use, I imagine most of you might use Duke MyChart. If you use that, you can upload a copy of your healthcare power of attorney and your living will to the MyChart. UNC has one too, so that it's on file for you. You can also file it with the Secretary of State. The Secretary of State has an advanced healthcare directives registry where basically you send them a copy of your healthcare power of attorney, they register it, they give you a little wallet card so that if you are in the hospital and you don't have your document on you, obviously, they should be able to use that wallet card to pull up your document from the state registry. I will say I don't recommend that as much these days because my dad several years ago had to have emergency surgery and I had done his healthcare power of attorney and I'd registered it with the state and the doctors didn't know what it was. You know, he's handing them the card and they just weren't familiar with it. But now now that they have that My Chart, everything's online, you can upload it. It's just always there in your chart. So that's really good to have. With financial powers of attorney, under that new law change, you do not have to record the power of attorney anymore. It used to be that you had to register your power of attorney with the Register of Deeds before you could use it. That's not the case anymore. If you're trying to sell real estate, you'll still have to register it, but otherwise you don't have to. And I don't typically recommend people automatically register their powers of attorney unless they're going to be needed soon. And that's because if you do register your financial power of attorney, meaning you take it to the Register of Deeds and it goes on file, and then you change your mind and you don't want that person to be your agent anymore, you have to serve them with a revocation, and then you have to file the revocation, and that can be uncomfortable. If you've got someone who you're going to be acting as their agent right away and you want to file it, fine. But otherwise, I don't typically recommend registering it right away. And it doesn't have to be registered. The only downside of not registering it, I would say, is that you then have to know where the original is. Once you register it, that's the same as the original.
What are the issues if you have a revocable trust and do a holistic will?
Are you saying, okay, so the question, I guess I don't need to repeat it because it's on the microphone, but the question is, if you have a revocable living trust and a holistic will, do you mean a holographic will? Okay, a holographic will is a will that you handwrite. And so, people kind of use them in emergency situations. Maybe they don't have time to get to an attorney. A lot of people do it. A lot of parents do it when they're on their way to vacation and they want to name the guardian of their child and they don't have time to get their will updated. So they handwrite their will. So that's called a holographic will. And it has to be 100% in your handwriting. It can't have portions typed and then signed. And they are valid. With a holographic will, if you had a holographic will and a revocable trust, what issues might there be? Well, your will is only going to control property that is in your name. So if you have a living trust and you've already titled assets to your living trust, then your will doesn't control any of those anymore. So let's say that, for example, you have all your checking accounts are in the name of your living trust and your house is still just in your name. So if you then wrote a will, your will could give away the house because that's still in your name, but it wouldn't have any control over what happens to those checking accounts that are already titled in the name of the trust. Usually, when you have a living trust, you will almost always also have a will, and we call that a pour over will. And basically what it does is it just states that anything that didn't get titled in the name of your trust goes to your trust at your death. And that's just to make sure that the same beneficiaries that you want to receive that property is going to receive it, even if you have an asset that didn't get titled in the trust.
What's that called again?
The pour over will. So, a pour over will. So we think of it like we're going to pour your assets into your trust. So it doesn't avoid probate. Anything that passes under that will is still going to go through probate, but it's there as, I like to think of it as a safety net. There's going to be assets that you might forget about. There's also going to be refunds that come in. Being able to have that directed to your trust is going to avoid any kind of discrepancy between what you want to happen.
Amazing. Okay, last question.
What sort of time frame do you have after a person dies to, settle up the investments at a revocable trust, something like that? And you might have some things that are somewhat illiquid that you might want to have a CD run out for a period of time.
Well, you don't, there's not a specific time frame necessarily that you have to get it settled if it's in a living trust. I usually recommend trying to get, the investments and things distributed to the beneficiaries sooner rather than later. And that's because while they're still investments, they're going to be paying dividends and buying new shares. That's one of the things where a trust is really beneficial for an investment account, because if you have an investment account that's going through probate, you're going to have to account for all of that activity from date of death forward, and it's super confusing. But even if you have it in a living trust, I still like to go ahead and get those things distributed to the beneficiaries, as long as we hold back enough cash to pay for the tax return and pay whatever bills are out there. Because while it's in the trust, it's going to be generating income. And then if it generates enough income, you're going to have to file tax returns for the trust. And so things that are earning income, I like to move out to the beneficiaries sooner rather than later.
A wealth of information, Dory. Thank you.
Thank you
so much. Yes. Stop in the back, some nice sweats and pens and all this stuff. Has her number on it. I'm sure she wouldn't mind if you gave her a call if you have some questions. But I just want to say thank you. This has been a wonderful series. I look forward to your evaluations, and we've got that one more session left. So thank you so much.
Thank you.
Oh, nice. Not much of a I think it's Doris. So just one letter shorter. Yeah, I almost never meet anyone.
I had one to Paris.
Yeah. Yeah, it's she. So,